We'll bring this subcommittee hearing to order. My apologies for being late. I was held up in another meeting and I apologize for that. We're here to consider House File 633, a bill for an act relating to certain companies that censor online content and providing civil penalties. Joining me on this subcommittee are Representative Jacobson, who put forth the bill, one of the co-sponsors, and Representative Wolf. Specifically, the bill defines dominant social media company. It goes on to state that the bill provides that within 30 days after a dominant social media company restricts a user's content that constitutes constitutionally protected speech on its social networking website or restricts a user's access to its social networking website, the dominant social media company shall provide the user with notice explaining why the user's content was restricted or why the user's access to the social networking website was restricted. The bill requires the Office of the Attorney General to enforce the provisions of a new code chapter 554E, assess a civil penalty for a violation of the new code chapter in an amount not to exceed $100,000 for each violation, and adopt rules to administer and interpret the bill. So that is the basics of the bill. At this time, if there's someone who would like to speak for or against the bill, please come forward and state your name. The microphone's right here, so for the benefit of those who are watching online, it'd be necessary for you to come up here and sit so folks can hear you on the mic. So if anyone would like to come forward,
Mr. Chairman, I'd just like to salute those of our colleagues and friends that are joining us by remote today, including the Council Bluffs Chamber President. I know Drew Camp is viewing today and wanted to give a shout out to all the good folks from my district and Council Bluffs who are tuned in today.
thank you. Anyone like to speak for or against? Seeing none? Okay. Representative Wolf?
There's somebody.
Oh,
There we go.
yeah.
What's up, me to go first?
Yeah.
That's a good thing.
Yeah.
We're still paying attention.
Linda Hicks from the Iowa Attorney General's office. We are registered neutral on the bill. From a policy perspective, obviously, it mentions us and it would have a considerable impact on our office. I just want to give for an example, I think you all know that we currently have lawsuits against two huge tech companies, Google and Facebook. That is the work of multiple years, multiple states, dozens and dozens of attorneys and staff, paralegal investigators, etc. Our interpretation of this bill, that it would not just look at two tech companies, we are potentially looking at this affecting YouTube, Facebook, Instagram, TikTok, WeChat, Twitter, WhatsApp, Snapchat, Reddit, Quora, Pinterest, and probably others. So this would, potentially, there's a potential for a lot of complaints coming into our office regarding this. So, we have put together a fiscal note regarding SF 402, and I'm sorry, the House bill that's, this is not going to be the same burden as those, but still there's going to be a substantial impact on our office to respond to these complaints and work with these social media companies. Not to mention that our office is also going to have to defend this bill if it becomes law. And at this point, we could have a discussion later about all the various constitutional and federal exemption questions that arise. I would refer you to a report that the Congressional Research Service did in 2019 on this question of regulation of social media. And I'll just quote in part: lawsuits predicated on these sites' decisions to host or remove content have been largely unsuccessful, facing at least two significant barriers under existing federal law. First, while individuals have sometimes alleged that these companies violated their free speech rights by discriminating against users' content, courts have held that the First Amendment, which provides protection against state action, is not implicated by the actions of these private companies. Second, courts have concluded that many non-constitutional claims are barred by Section 230 of the Communications Decency Act. which provides immunity to providers of interactive computer services, including social media providers, both for certain decisions to host content created by others and for actions taken voluntarily and in good faith to restrict access to objectionable material. So you see, again, we can go into more detail on some of those, but we're looking at some considerable challenges if this goes into law. Thank you for listening, and be happy to answer the questions.
Yeah, and I'd like to ask you a question or two also. Go ahead, President.
Thank you, Mr. Chair. So I was just looking, section 3 of the bill that requires the AG's office to enforce it. And then I guess specifically on page 2, line 4, that it requires you, it says shall assess a civil penalty in an amount not to exceed $100,000. So I was trying to contemplate whether that you would first have to file a civil lawsuit and then have proof, preponderance of evidence that they did in fact do what you're fining them for, or would there be some other way? Like you could just say, we're looking at this and you clearly did what you weren't supposed to do, so we're assessing a fine. I mean, does the Attorney General assess fines?
We don't.
Okay.
Under the Consumer Protection Act, the Consumer Fraud Act, I should say, well, first of all, there's a higher standard of proof than a regular civil lawsuit. And so there has to be clear preponderance of a violation. We would have to file a lawsuit, and we would have to ask a judge to assess a penalty. Obviously, we can't assess a fine, we'd have to ask a judge to do so. $100,000 is much more than the Consumer Fraud Act allows for $40,000 per violation, up to $40,000 per violation. So, it's quite a bit larger. The courts would have to decide whether this is remedial or compensatory, or it's penal in nature. And that would be a question for the courts.
One other quick question. If you know, would defendants in one of these lawsuits, would they have an automatic right to remove it to federal court, since they operate in many states?
Well,
And if
I
you
would
know,
speculate that would be an attempt. I don't know if that would be
Okay.
on track.
all right, thank you.
Representative Jackson, did you have any questions?
Not at this time. I do congratulate the Attorney General's office, however, for joining with 48 other states in their suit against Facebook for monopolistic practices, and that will impact my comments, so I'll make a conclusion here. Thank you, Mr. Whitney.
Okay, I think some of what Representative Wolf asked was kind of what I wanted to talk about too, so I'll just, right now, I think I'm good to go. Thank you so much for coming in, I
Thanks for
appreciate your
the
comments.
call.
Thank you. Representative Wolf, would you like to hear your comments?
No,
Oh, I'm
thank
sorry,
you.
is there anybody else that wanted to speak? I didn't think there was, but, okay. Representative Wolf?
No, thank you.
Thank you, Mr. Chairman. I had some outside remote hope that Mr. Zuckerberg would join us. I have the booster chair here for him, if he does appear to show. A couple threads here. I think the first one is, if you look at the case law, and Representative Wolf and I did this routinely at Iowa. We started out reading some of the great cases: Marsh v. Alabama, Manhattan Community Access versus Halleck, Burton versus Wilmington Park Authority. Within the ambit of that exploration, as always, what's the public square? What's the town hall? What's the state actor? And this is an evolving process of law, because it used to be the town square was the literal town square, circumscribed by the local businesses. It might have been with the monastery in the middle, and in small town Iowa, it was where the courthouse literally was, and the lawyers' shops, and the constables, and the retails around there. And it's always been held that there's a right to pamphlet, that's part of the town square, and that you cannot abrogate that right. So we've had these fights throughout history. What's a state actor? You know, is a parking lot different than a shopping center? Is a byway different from an area that's highly regulated by the county or the city? And the law has evolved. There have been a lot of close decisions. There have been a lot of 5-4s even lately. And ironically, it's justices like Sotomayor and Kagan and Breyer who are more willing to find a state actor nexus when the government is involved with these venues, let's say. Some venues are not physical. We're now in almost a digital venue type of area. And so with that said, we see an evolving law, and many of the courts have narrowly construed their cases. So as you know, the dicta even is pretty narrow in these cases. We're deciding cases ad hoc based on the fact patterns. But I believe we're very close to a point here. Some of the dissenting opinions and some of the dicta has basically talked about these multi-pronged tests for what's a state actor and what's not a state actor. I think right now, and the focus of this bill obviously is similar to my colleague in Nebraska's unicameral who had a particular isolation on Facebook, but not to be limited to Facebook. But the idea of, you know, are they a state actor in that there's now so much nexus with the government, even cooperating with government agencies and releasing some data, you know, criminal, search and due diligence and things like that. Not that that's a problem, that may be a very good thing, but it still shows that nexus of state actor. So either they are a de facto state actor, or it's binary, or they have subsumed and become the public square and obliterated the traditional public square by an illegal monopoly. And our own good Democrat Attorney General is after Facebook from the monopoly standpoint. So if you're a monopoly, you obliterate the public square by subsuming it. If you're not a monopoly, you're a state actor. And I look at the deplatforming that's going on simply because of differences of opinion. I'm going to use one anecdote. During the entire, we're almost coming up 12 months on COVID, Facebook absolutely scrubbed if you were an advocate for the hydroxychloroquine, zinc, Zithromax therapy. You were either screened off, filmed off, possibly deplatformed. And our federal government now, after January 20 miracle of predictable coincidences, says, oh yeah, you know, hydroxychloroquine worked all the time. Well, we knew it because I did my due diligence. I talked to the doctors in the trenches who were treating people, not the Poindexter egghead antivirologists that were looking for the wraith of some miracle vaccine out there that is, you know, will be Ahab chasing Moby Dick forever. Not focusing on antiviral or other therapies or treatments, not focusing on prevention, vitamin D, zinc, all those therapies. And that suppression of a therapy that was used in my metro area by doctors in the trenches that had curative, cheap, available remedial effects, this is the danger of a monopoly that has subsumed a public square, or worse yet, a state actor that is now absolutely quashing medical data that is truthful and scientifically proven. So yeah, we've got a hell of a problem here. Now, this bill is in its early stages here. I am open to many ideas of amendments. Obviously, the 554E, bringing in some of the other entities, the schools, the contractual obligations that are there. I'm certainly willing to not impede and encumber our schools from having to vitiate contracts that they already have with multi-platforms. I realize that beyond Facebook. We have YouTube and Google, and I don't quite have the bone of contention with them at this juncture. The applications. You know, there's a difference between the application stores and the platforms. Get that? Understand that. We can accommodate some of these things. The whole litigation piece. You know, I know that this augurs for this being fought out in Duke Court, and you know, Iowa had Tinker versus Des Moines Community School District. Why not be another landmark case in Iowa in testing the limits of free speech? But I had a town hall in Trainer last week. I was joined by Representatives Nordman and Mitchell, and they would tell you that the number one issue, and the people were piping hot mad about it, was the deplatforming and the censoring of our citizens on social media and in educational institutions. And something's got to be done about it. So with very open, I really respect my colleague Representative Strike. I know he'll have some good ideas on how maybe to ameliorate some of the issues here. He's a very compelling advocate for his folks. And Mr. Camp today raised some of these issues I've just talked about that I really think are worth exploring. But Mr. Chairman, at this juncture, I support this bill, and I'd like to see it moved to committee for discussion with some amendments.
Well, I thank everybody for being here today. I'm seeing both sides of this issue. I see a number of challenges with practically putting this or the Senate bill into action from a practical point of view. I appreciate the comments of the Attorney General. That was very helpful, and we'll definitely be reaching out to you. But I am concerned about big tech media censorship and what now is clearly a major part of the public square, and that is the media platforms where there's so much of an exchange of information and ideas. So I'm going to advance this bill to continue the discussion, but I understand absolutely the work we have to do. I understand the implications of what we're doing. I understand how much we have to do to make this workable, and we also have to be respectful of private companies and their rights as well. So there are a lot of realities we're dealing with. I think I see them very well, including what the Attorney General would go through and try to enforce some of this. So I appreciate the discussion. I'm going to advance the bill to keep the conversation going, but again, I understand a lot of the realities we're dealing with here. Okay. Thank you very much. Have a good day.
I sign off, but I just want you to know I respect, you know, what you've done here, and I think it's very interesting, and it is kind of like a law school, you know, exam question. And I am on the Justice Systems Budget Sub, and so I heard the AG tell us how they are really tight. So if it's something where additional funding for the AG could be built into the bill, I think it'd be much more palatable. So
I appreciate your comments very much, and I would echo what the chairman said about trying to find that balance with private enterprise as well. And the irony I found, just sidebar, Representative Wolf, is that in reviewing the free speech cases today, it is interesting to me that in terms of a more liberal construence of what's the public square, Breyer sort of orientated more language on this, and the Attorney General, Democrat, good man that he is more aligned with the monopolistic issues involving some high tech. So this transcends merely partisan lines. You've got a lot of moving parts.
so I think a lot of,
Representative Jacobson, my only question is, do we have to refer to Doug as Representative Strike? If we do,
Well, once a rep, always a rep.